Sir, you want to talk to me while we're waiting?
Oh, yes, sir, we can. We just have that Sullivan.
You wanted to do a proper pause on, Mr. Sullivan?
To be quite frank with you, I don't even remember what happened. It's an
The
assault.
allegation, let the state,
Yeah, so-
tell you.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a disturbance call and met with the complainant witness, stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
Right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
Oh, that's 10 minutes
That's
later.
10 minutes later.
All right, things are already getting tense here. The judge doesn't even remember the case at first, which is never a great sign for either side. But watch closely, once the facts start coming in, this quickly turns into a debate about fairness, self-defense, and who really started it. Question for you, if someone tells you to hit them, should that count as consent in the eyes of the law?
Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're gonna make.
What?
She asked, she or her daughter told her that, you have to make a choice between,
Oh, that's right. Yeah. I
and your,
remember.
and
And then she makes a choice of him.
And she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her, or to hit him.
Can't consent
Well, but that's, I
consent
mean-
to an offense, Judge. If he
can't
tells me
consent
to
to
shoot
assault.
me,
Yeah, no. I mean, you can, like,
Yeah.
boxers consent
You
to
can
assault,
consent to
right?
assault. That's
But, I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one.
Now this is the turning point. The judge is asking the exact question everyone's thinking: why is only one person being charged? Legally, this comes down to cooling off period and primary aggressor. Even if she hit him first, the fact that he allegedly came back 10 minutes later and escalated things could reset the situation entirely. But what do you think? Does that 10-minute gap really change everything?
Being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's
She's
it
still
fair that she's
assaulted.
not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious
Come on,
bodily.
Mr. Sullivan.
It's less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that
Right.
occurs, you know, so.
I would argue, Judge, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward, but I think that's.
And I think it'll work to the benefit, you know. So, Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand. And I don't know. But be it as it may, just don't have contact with this person. I think that, it's just could be like a rumbling volcano. And the last thing we want to do is we don't want anything more.
And there it is, the judge makes the call. Probable cause stands, and the warning couldn't be clearer: stay away, or this rumbling volcano will explode into something much worse. No contact orders like this are serious. One violation can land you right back in jail. But here's the bigger twist: the defense is still pushing for charges against the other party. Do you think the DA will actually file them later?
To erupt. We don't want further charges, and just, and I think that, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
But Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where they have filed charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time. I've seen cases where the district attorney filed cases 1 year later, when they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
I gotta put some money.
Go. Take your time. Just come back.
Okay, I will. Thank you.